Section 223, subsection 1, part C of the Penal Code Act, Cap 128. 2. Misprision of treason, contrary to section 25 of the Penal Code Act, Cap 128. The prosecution alleges that the applicants and others still at large between the year 2003 and November 2024, while in various cities, including Geneva, Switzerland, Athens, Greece, Nairobi, Kenya, and Kampala, Uganda, contrived a plot, act, or matter by force of arms to overturn the government of Uganda, as by law established and expressed or declared such plot, act, or matter by utterances and overt acts. In the alternative, the prosecution alleged that the applicants and others still at large in the places and in the time frame aforementioned, knowing that another person intended to commit treason, did not report the same to the authorities or use all reasonable endeavors to prevent the commission of treason. Legal basis of the application. The applicant brought this application by notice of motion under Article 23, Clause 6 of the Constitution of the Republic of Uganda, 1995, Section 15 and 16 of the Trial on Indictments Act, Cap 25, and Rule 2 of the Judicature Criminal Procedure Applications Rules, for orders that A. The applicant be admitted to bail and released from remand / custody. The grounds of this application stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that A. On the 21st day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrates Court of Nakawa at Nakawa and remanded in custody. B. The offences with which the applicants are charged are only bailable by this honorable court. C. The applicants are responsible citizens of Uganda who have permanent places of abode as follows. First, applicant at Buyinja LC1, Wampeo Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukonjiri Municipality in Rukonjiri District. Second applicant at Kisigula Village Cell, Mutundwe Ward, Gombolola Sabagabo, Makindye Wakiso District for the second applicant. The applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for mention or trial as and when once released on bail. Illustrate this respect for the law and for any bail processes they have benefited from. The applicants have not been committed to High Court for trial and are willing to comply with all reasonable conditions set for their admittance to bail. G. The applicants are of advanced age and have substantial sureties who are willing to ensure compliance with bail conditions once applicants are released on bail. H. It is fair and just that the applicants be admitted to bail and released accordingly. At the hearing, the applicants were jointly represented by Honorable Elias Lukwago, Mr. Ernest Kalibala, Mr. Apollo Katumba, Mr. Wanda Samuel, Mr. Samuel Moyezi, Mr. Kunhira Proskovia, MS Kunhira Proskovia, Mr. Kato Tumusimi, Mr. Bayan Turinawe, Mr. Farouk Kamulegeya, Mr. Kintu Michael, Mr. Amanya Timothy. The respondent was represented by Chief State Attorney Joseph Chomuhendo and Chief State Attorney Richard Birivumbuka. Both the applicants and respondents made oral submissions at the hearing and filed written submissions for which this court is grateful. The said submissions have been considered where necessary. Submissions as follows. Article 23, 6A of the Constitution of the Republic of Uganda, as amended, spells out the right of an accused person to apply for bail and enables this court to grant bail on such conditions as it considers reasonable. Section 15 of the TIA, Cap 25, provides that this honorable court may at any stage of the proceedings release the accused person on bail. Pursuant to Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Constitutional Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel further cited the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. Once the exceptional circumstances are listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16th November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Besigye Charles versus Uganda, criminal application number 8 of 2011, counsel stated that the courts have recognized that prison conditions are not favorable to the health of old people, who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides for that the other factors that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants said that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious, grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. That in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24 of 2024, the International Crimes Division of the High Court, ICD, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application. And here the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provided that doing so does not compromise the interests of justice. It was further submitted for the applicants that the nature of the offenses with which the applicants are charged are political offenses, and that these two are not. And on that account alone, the kind of offenses in respect of which bail cannot be granted, that the first applicant particularly has been charged with various political offenses over the years, offenses in respect of which no conviction has been returned by the respondent. Counsel cited Makoha Samuel and 35 others versus Uganda, Supra. Counsel submitted that other conditions to be proved before court include of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panju versus R 1973 South African Law Reports at page 282, where the court held that allegations of interference with witnesses must be substantiated, and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in applications for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. Guideline 3 of the bail provides conditions that court should take into account in considering bail applications, including the substantiality of sureties, nature of the offenses, age of the applicant, possibility of interfering with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties, the age, work, residence of the sureties, character and antecedents of the surety, relationship of the surety to the accused, stroke applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties, to wit, Honorable Semuju Nganda, a close friend, age 52 years. Honorable Francis Mujuche, a close friend, age 41 years. Honorable Mohindo Harold Tony, a close friend, age 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, age 50 years. And that the second applicant, produced by Najita Halima, the second applicant produced Najita Halima Lutale, a wife and aged 58 years. Namfuka Zuhura, a daughter aged 27 years. And Counsel Sewan Kambo Hamza, a friend aged 48 years. Counsel submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And in such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. Counsel cited the case of Mugera John versus Uganda, criminal administrative application number 21 held. It is my considered view that a surety should possess a certain amount of authority and/or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from LC1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, Council submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. And produce only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Council add that friends do not have the necessary leverage or influence to ensure the first applicant's compliance and are most likely unwilling to take steps to enforce compliance. Council cited the case of Tusime David versus Uganda Criminal Minister Subsection number 29 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Council said that if court was uncomfortable with raising the applicant based on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to release the first applicant with just friends as sureties. In his submissions, Council submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicants dispense this requirement. Council cited the case of Mugera John versus Uganda, Business Application number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Aliviza upheld the above view. It was further submitted that none of the sureties provide their work or business identity cards. What was annexed are passports and national IDs, which have no relationship with the business or employment or gainful income and disposable income, which are critical in assessing their substantiality. In Asimu Anna versus Uganda, Criminal Minister Subsection number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability by the sureties, regardless of their position in society or government, is fatal and goes to the core in the grant of bail applications. Advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved, as was held in the case of Tumusime David versus Uganda, Criminal Miscellaneous Application number 29 of 2019. The offenses with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Kano, retired Dr. Kiiza Besigye, Constitutional Reference number 20 of 2005, the Justice of the Constitutional Court held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offenses. The court must weigh the gravity of the offense and all other factors of the case against the likelihood of the applicant absconding.
Chief State Attorney.